Hi, this is Keena Kim with PivotalDiscovery.com. Today we're here with Chris Dale and Browning Marean at ILTA09, and they're going to talk about being a stranger in a strange land, and what does that mean with regard to eDiscovery. Thank you, gentlemen, for joining us.
Well, thank you very much. Chris Dale and I have had the great pleasure of getting to know each other over the years through my trips to the UK and Chris's trips to the United States. And one of the topics that we talk about a great deal is electronic discovery, or eDisclosure,
as we call it in England.
Yes, more properly, indeed. And the one thing that has struck me as I get to wander the globe is the extent to which one really is a stranger in a strange land when it comes to understanding discovery or disclosure processes in different jurisdictions. Chris, I think the case that brought it home to me was reading the Digicel case, which I found a fascinating primer on eDisclosure practices.
As did a great many English lawyers and judges who found, to their amazement, there was a whole practice direction guiding them through the process of eDisclosure, which the judge in Digicel went through very carefully. And for many, it was their first knowledge that we had such a thing.
Well, you know, increasingly we're seeing states, for example, California just enacted changes to its eDiscovery rules, which really goes a long way towards harmonizing California practice with the federal practice. You go from one jurisdiction to another, for example, going to Texas. Their rules of civil procedure have a different, very short rule on electronic discovery, but it appears to be quite efficacious.
And is it surprising that American lawyers find it hard to keep up with this?
Yes. You know, there are a couple of wonderful sources out there. In some respects, this being a child of technology, there are some wonderful resources on the internet. Your blog is a must read. It's just, you can Google it and find it very, very quickly. Other sources, Ralph Lossi's excellent blog, which if you just Google Ralph Lossi, you'll get to that fairly quickly. That and K&L Gates is a wonderful site as well for keeping up and maintaining levels of competence.
One of the issues I think we have here is that people are embarrassed to ask because either they feel they ought to know and they don't, or they would rather it simply didn't happen. And they're shy of asking. And one of the real issues that I face is persuading people to acquire the basic information in the first place by secretly going off and looking at somebody's blog or website. You don't have to ring somebody up and display your ignorance if that's what you've got. There's plenty of resources for finding out behind the scenes.
Yes. Well, you know, Chris and I and George Sosha are co-chairing a program in London this coming November. I think it's our third or fourth such experience. And those are always fascinating for me because it gives me much better insights into what's going on in the UK. One of the resources that you have there is something called the List Group. What's that about?
The List Group is a London-based group of eDisclosure or litigation support managers in the larger London firms who are very much thought leaders in the practice, how to get the lawyers to do what's sensible as well as what's right by the rules, and encouraging between themselves, because they all know each other, a liaison in a way that the rules require, as your rules require, and as your judgments increasingly require. And the idea is they all know each other, they can pick up the phone and they say, we've got this problem and this problem, how are we going to solve it? And that is, as I say, what our practice direction specifically requires. And well, it was the defect in Digicel.
Yes. Well, one of the things that we see in our cases is the need for cooperation. Although it's apparent to me that, at least in the States, we need playground monitors quite a bit in order to regulate what the List Group is apparently able to accomplish.
Do your rules actually require cooperation?
Absolutely.
Expressly.
Expressly. However, that cooperation is honored, unfortunately, more in the breach than the observance.
And what happens to people who don't follow that bit of the law?
Well, unfortunately, most of the time, there are no consequences. There are some cases now coming down in which the consequences for failure to cooperate are severe, but I sense that those cases are probably still outliers in terms of practice.
We don't, as you know, have sanctions in the English courts. The penalty is a cost penalty, reimbursing the other side for costs that have been wasted as a result of the failure to cooperate. The real issue arises when neither side cooperates. So penalty and cost is not appropriate because you're simply finding it's a reciprocal burden.
Yes. In reading your blog, I saw a reference to Lord Justice Jackson, a forthcoming report. What is that going to? What impact do you think that may have on eDisclosure?
Potentially a very enormous impact. Lord Justice Jackson is a Court of Appeal judge who has been given the job of reviewing the whole question of litigation costs, not just eDiscovery, not just discovery indeed, but how litigation is funded, how we can bring the cost down, how we can restore justice, which is what it's really about. He delivered an interim report in May, which had a whole section on eDisclosure, and his final report is due out in November, and is expected to have big changes, big effects, big changes.
Well, you know, the cost issue is expressed in the states with the challenge of proportionality. That is, just how much effort and cost should be associated with the eDiscovery process, and that's a huge challenge because the question of whether people will settle a case rather in order to avoid the significant costs associated with eDiscovery really goes to an access to justice issue.
That's expressed in a couple of our judgments, including Digicel, by reference to not appearing under every stone. And that's difficult enough in our jurisdiction. I think it's rather harder in yours, where the fear of sanctions drives people in the other direction.
Yes, you know, I think, again, sanctions, while the cases certainly discuss them, I think in some respects fear of sanctions is somewhat overblown.
But nevertheless it exists.
Nevertheless it exists, and it does keep you awake at night.
Well, thank you, gentlemen, for joining us today.